Good afternoon. This is Craig Friedberg. You're watching Attorneys Forum. I'm a consumer protection attorney here in Las Vegas, Nevada. With me today is Alan Woodman of Sidekick Publications. Hi, Alan.
Hi, how you doing? Thanks
All right.
again.
Go ahead.
I had a question for you. And
Yes.
This is a piece that actually I did some research. I wrote a book called I co-authored a book called Martial Arts Guide to Success, and it was basically almost a 400-page manual of how to make your martial arts school successful, and gain market, and get students to be involved, and how to be involved in the community. That's the focus of the book. One of the portions that I did a lot of research on was the legal portion of the difference between what most schools use as a general waiver, as in we waive a student who comes in and says, sign the waiver that says I waive all my rights to possible injury and blah, blah, blah. Against the fact, what I found to be a much better legal source is the assumption of risk form. Means that the person is going to assume the risk of the activity that they're participating in, and that's very clearly spelled out in assumption of risk. And so I thought that would probably be right up your alley.
Well, you have done good research on that. That's good, Alan. And going towards, and reiterating the point that if you are going to sign up with one of these schools, you absolutely need to read all the paperwork. Not only the paperwork that says that I'm agreeing to come in, I'm agreeing to make payments, and you need to make sure that you see how you're supposed to make the payments and what you're obligated, whether if there's a termination clause that says that you can give them 2 weeks notice, 4 weeks notice, 30-day notice, something like that, in which at the end of that, then you are released from the financial obligations. Some do, some don't. But also, you're going to often see paperwork, just like Alan was just mentioning, which is some kind of waiver or risk assumption to try to preclude the owners of the dojo, of that martial arts school, from any liability should something happen to you, should you have some type of personal injury while you're there. And the difference between waivers and assumption of risk can be murky. And also, this is a state-by-state type of situation. A state like California, which is known for having much stronger consumer protection laws than, let's say, a state like Nevada, will look at these in different ways. But the thing that, as a consumer, you need to look at is, what are you agreeing to waive? Whether it's, no matter what the name of it is at the top of that document. One of the things that most states will not allow someone to force a waiver on a consumer is a waiver of their what's called active or actual negligence. And that can be anything from them telling you to do, let's say, some type of position, or to get involved in some kind of interaction with another student or with a teacher that they know will likely lead to some kind of injury, and then that injury occurs. Another way is, for example, whether a tile is sticking up from the floor, and it's something that is not easily seen, so you can't say they can't say that you should have seen it there, or a piece of the ceiling falls down. Yeah. They can't waive, and that piece of ceiling is something that they knew was there. And knowledge is an important part of this.
On that, let me ask a hypothetical.
Yes.
Most martial arts schools have them, almost all of them that I know of, have mirrors on the wall.
Right.
And a student loses their balance, or they're kicked or pushed during a technique of some kind. They fall into the mirror breaks, falls on them, they get cut.
Okay. If they have a good assumption of risk, then most assumption of risk documents are very industry specific, meaning that when you're dealing with martial arts or a martial arts school, especially, I've never seen a martial arts school that didn't have mirrors all over.
I've seen a few.
It's
rare.
It's like a dance studio.
Yeah, that's right.
You have mirrors all over the place. And they're important.
They're instructional aids. So.
Absolutely. So most assumption of risks that certainly were written by other attorneys will include in the opening paragraphs kind of an outline of those things that might occur. And when those things would include, they can say there's mirror or there's glass that surrounds the students. And it's a possibility that a student, through no fault other than the student losing balance, may break a mirror and may get cut by the mirror or have some personal injuries as a result of that. If you sign off on that type of risk, then you have
covered.
waived. Yeah,
But it
they're
has to be
covered.
very specific about
It
that.
really does. You know, you were talking before during the break that you've seen waivers where it's just very general.
Oh, it's very. It says, you know, I'm waiving my rights to any injury or financial gain that may occur in, you know, an injury that occurs here on these premises or in this school with this student
Right.
or something. And and it's very general. And almost every martial arts school thinks that they're great.
Yeah.
And I try to tell them no.
And in many states that would have absolutely no effect. Even in other states where the court may try to put some effect, basically the effect would probably be for some type of general waiver is that they may be able to waive those things that they do not know about. All right, in a grocery store, if someone slips and falls on you know, a piece of a tile, all right, let's say. And the
Or a mat
store
that slips on the
right,
floor, for
or a
example,
mat.
yeah.
That's even a better one. And the store had notice or knowledge that mat
That
is
slips,
not is not the right one for the surface it's laying on, so that it will slide, especially if there's water or
Right.
something else, and it's near, let's say, live grocery where there's sprinklers and misters.
Right.
Then they're not going to be able to get away with a waiver like that. If it's something that's never happened before, there's no notice that by the owner of the school that type of situation could occur and cause injury, then in some states they will allow that type of waiver to have an effect.
It'd be permissible under those standards, right?
Right, but it's very fact specific.
Yeah.
And it certainly wouldn't likely keep that school owner from being sued. It just may allow him to be able to defend the lawsuit.
Right. So a lot of people I know, a lot of friends who have martial arts schools. So check what you're doing on paper. You know.
Right.
Waiver, assumption of risk.
Right.
And just out of legal expertise, which is better in general, assumption of risk form or waiver?
Assumption of risk form is always better. The more detailed, the better. And when you're coming in, read through those assumption of risk. They can be in small print. They may be hard to read. Take out your glasses if you need it. Give it to someone that will read it for you if you're having problems, because that really will define the parameters of what that school is going to be responsible for should something occur and you get injured while you're going to that school. You know, some other things that they should know about is, and especially from going on, if possible, websites that the court system set up. You can often go into and on that website and see whether that particular school, find out what the actual name of the school is, whether they've been sued. And you can do that usually by a party lookup. And most of the courts in California, many of the courts in the larger metropolitan areas of Nevada have these open to the public. So all you need to do is go to that website, log in, and then put in the name or the of
company name,
yeah,
or
of the
the
company
school
name,
name, or-
right, or the school name, or even the individual
owner,
owner
yeah.
name, or do all three if they're different. The other thing to do, if you don't know what that is go to that state's Secretary of State site and find out what the correct business name is. Because most attorneys are going to do the same thing. So they're going to sue that business under the correct business name. And that's why you want to use that correct business name if you're looking up to see whether this is a school that has been sued before and what types of suits they've been involved in. You might not be able to actually pull up the complaint, but oftentimes you can get a general idea from the docket that
And
you're
you're
able to see.
looking if they've been sued or not been sued.
Oh, absolutely.
Yeah.
Absolutely. I mean, that's just one more thing to do. You've been watching Attorneys Forum. We have another segment left. My name is Craig Friedberg. With me is Alan Woodman, and we'll be back in a few minutes. Thank you very much for watching.